for instance, how do you collect money that's owed? Is the council the entity that is supposed to sue the district attorney to get reimbursed on payment of training expenses that were abused? There's no thought to what goes beyond the finding of impropriety.
Yeah, I wanted to add that one of the ways that PAC, when I came into office, there was a large bill that my office owed. And Pete was very, very kind, but it was understood that if I didn't settle that debt, that all of my spacer employees would be cut off. They weren't going to agree to do that. So we nickel and dimed ourselves to pay that. As the DA of a circuit that is primarily rural, I don't believe I have a whole lot of say at all. And what I mean by that is just like when we sustained those large cuts in our grant funding that funded our victim advocates, I was just told, right, you're going from a little over 350,000 down to 170. And Pete and the PAC staff will tell you that I had a conniption over it.
Yeah.
All right. I don't have as much influence as one would think as it pertains to HR, budget, money. I just don't. But as to misconduct, as to questionable behavior, and I understand that it is just now getting off the ground, but 151832 subsection H outlines 6 different ways, and willful misconduct in office is one of them. Willful and persistent failure to carry out your duties pursuant to 1518.6. Knowing conduct prejudicial to the administration of justice which brings the office into disrepute. We now have, in my humble opinion, more guardrails than we've ever had. And I think that was the
statutory or through that council?
That 151832.
Okay.
I will tell this entire committee, and I've told numerous people, I don't work for PAC, and PAC provides a lot of resources. If you look at the legislative intent of why PAC was created, PAC was truly created to be a resource for district attorneys. PAC's influence has expanded in a lot of different ways, from conflict attorneys that they recently took over, training, HR, and you've got the council, you do. But I believe that who holds us accountable is the voters, and also here, right now, if the oversight bill, and that may, as it continues to roll out, need to be tweaked.
Right.
One of the things that I think should be included in that is assistant district attorneys. Not just district attorneys, but assistant district attorneys.
Sure. Any prosecutor, really.
Right. And there's a whole nother subsection, as you know, as it pertains to charging, whether or not to charge a case. And, you know, it outlines the ways in which you might get in hot water for charging a case. If there's a conflict of interest or a financial benefit at hand, so forth. So I think from a statutory standpoint, we're in a better position than we've ever been as a state, as a community, to ensure that DAs are doing what they're supposed to do and not misbehaving.
Do you count yourself?
If I may jump in, Mr. Chairman, and piggyback on what Wright just said, because I think that this is important. I do have a policy and procedures, manual that my employees have to sign when they come and work for me. And it is tailored to my circuit, and it's very detailed. I did that when I became a district attorney, and I think I want to push back a little bit in an extremely respectful way, Mr. Chairman, on the idea that there are those of us out there that aren't doing that. Most of us, Chairman, most of us out here are keeping our head down, doing our jobs, serving the public, trying the cases, moving cases, making sure a case doesn't sit for years and years before a victim finds justice. And I just wanted to fight a little bit for those of us out here who are doing that. And we might be quieter and you might not hear from us necessarily. And I think that's why it's important that we're sitting in front of you today, because that just means we're working. And so I just wanted to put that out there. And the reality of the budgets that we're operating under and the constraints that we're operating under. I mean, my employees in Spalding County were frustrated because they had to share a box of paper clips. I mean, this is real life stuff that we're fighting for every day. I mean, we fight for every penny that we get to support our employees, yes, but also support the taxpayers and support the citizens of the circuits that we serve. And so I just wanted that to be part of my testimony today, Mr. Chairman. Thank you.
That's great. Okay, so.
And just to be sure, from a large metro county, I had a policy and procedure manual. It outlined not only procedures like county cars and guns, and so it was partially for liability purposes, but it had a code of conduct, and I would enforce it.
Did you feel bound by that? That's a county policy, not your DA's
No,
office.
it's a DA policy.
Okay. Do any of you
DA
feel
policy.
like the county in which you serve can impose any employee policies on you?
They do.
For the county employees, they can.
All right. Okay. And you have this blend of state employees and county employees?
Correct.
Okay. Why would you ever want to treat them differently? You're going to treat your state-paid assistant district attorneys differently, standards of conduct, et cetera, than your county paid?
I didn't. I mean.
Do you think the county can impose those duties on you? They're having this battle in Fulton County. The Madam DA in Fulton County says she ain't got to do what Fulton County tells her to do with whistleblowers, with treatment of employees, or anything, because she is a constitutional officer. She can set her own darn policies. Do other DAs feel like you're bound by county policies and procedures on employment?
No, I never felt like I was bound by I was bound by my word that I would agree to that my employees would submit to it. And there were times when something came out of the county that I thought was stupid, and I said, we're not going to do that. And I exercised. So, in a way, based on the case law, the district attorney in Fulton County is correct that they can't. There's no mechanism in either state law or the case law that allows the county to impose its will on an elected constitutional officer.
Can they make you treat county-paid employees in accordance with county policies, including nepotism and?
No.
They cannot?
No.
Okay. Well, then maybe we need a state law to impose this on you people so y'all will treat our employees fairly. We're paying for all of them, one way or the other. Citizens are,
Well,
either through county funds or state funds.
Can I?
If I may interject
See,
here.
this tension I'm trying to bring out, because there is.
Sure.
Constitutional officers want to run their show and not be told by county governments how to do it.
What-
State government's not telling you how to do it. Y'all are saying we're kings, we can do what we want to do, you just got to trust us.
One thing that Murray, go ahead.
Right, can I jump in really quick? Yeah, and answer your question. And because I want to highlight something here, Mr. Chairman, that I think is very important for the commission to understand. I have one county employee. That's it. And that's because she retired from the state and she could not receive state benefits. So I went to Spalding County and begged them to hire her on as a county employee. That's my only county employee. The other ways that they're funded, and I think this is where maybe some confusion comes in, is the rest of mine are state paid, county reimbursed. They're either state paid or they're state paid, county reimbursed, meaning that PAC pays their salary and I reimburse PAC either with grant funding for my victim advocates or my investigators, or with county money that the county gives me to then reimburse PAC.
So does that make them a state
lot
employee or a county employee? If they're
state employees, sir.
Okay, so all of your people are state, even if they're paid by the county? State paid, county reimbursed?
Except for one.
Okay. I didn't
Yes.
mean to interrupt you. Go ahead.
No, I'm sorry, Mr. Chairman. Thank you for that. I needed to clarify that. So that's how a lot of us operate out here. A lot of us don't have a lot of county employees. So I think this is a more isolated problem than you're going to see across the state, because most of my employees, like I said, are state employees. They receive state benefits, but the county has agreed to reimburse the state for them to have those benefits. It's easier on your smaller counties because they don't have to carry the actual employee. They just give the money over and then the state gets it from them. So I wanted to make that clarification, right? I don't know how many actual county employees you have, but I only have one. So that really wouldn't be, and that happened this year. So that wouldn't be a problem in my circuit.
The issue that, and I hear what you're saying. First, I want to tell you, I'm not a king, and my wife reminds me of that on a daily basis. All right. The problem that I have, and I'm fine. Look, I'm fine with whatever. It doesn't bother me. The problem I have is I have 8 counties, and I'll use an example. There are certain holidays where Jones County and Wilkinson County take the holiday, but Greene and Putnam and Hancock County don't. And so if I get 8 counties with 8 different operating and procedures or how employees do, most of my county employees have to sign certain county handbooks and that kind of thing. And I'll tell you, that's the complicating issue. If I had my magic wand, how would this all improve and be great? Is that for the DA's offices to be 100% funded by the state of Georgia. Practically speaking, that would be an astronomical price tag. But that would be a wonderful thing for me in my office, because right now what you're highlighting is why I started to have gray hair. Is I've got 8 county budgets, 8 county sets of county commissioners. I've got the state legislature. I've got PAC. I've got a lot of people, and when you get a lot of people in the room, it's very difficult at times because they may define things differently, and it's hard to comply with whatever that is. I'll tell you this. I did not fire her. I asked her to resign. My best trial attorney, I asked her to resign because I caught her in a lie to one of my judges. I will tell you that I personally have had to make a tough decision as it pertains to my employees. I had one test positive for THC, fired her on the spot. There are time and time again where we've got to make tough decisions. I'm certainly fine with oversight, but to have a clear set of directives is what I'm asking. I can only speak for me. What are those directives?
And that's kind of what I'm probing, and I'm playing a little devil's advocate here with y'all. Don't perceive me as being antagonistic. I'm very concerned that we don't have any universal, consistent codes of conduct for prosecutors. What are the ethical guidelines? What are the fair expectations of our citizens? And I'm seeing the reason is because, as far as I can tell, they're only bound by the disciplinary rules and ethical guidelines of the State Bar of Georgia that apply to all attorneys. I don't see where PAC has ever enacted any. And what I'm hearing is even if you do, you can't enforce them. And I'm hearing you also say counties can't enact them on us because we're kings and queens. And I'm saying that joking. You are constitutional officers. You are elected by citizens. Your positions are created by the Constitution. And for good cause, you need to have independence. Senator Jones would agree with me as an ex-solicitor. You don't need us meddling in your business. But as far as ethical guidelines and expectations, what the public deserves so that they can have a feeling that they're going to get fair and impartial treatment in the criminal justice system, which to me is more important than the civil justice system where we're just trying to sue you for money. The criminal system, we're going to put you in jail and take your money as a fine. You ought to have an expectation that the people in there that are prosecuting you and the judges that are ruling over the cases are going to be bound by universally accepted and understood ethical guidelines, and that the guardrails, as we're talking about.
Senator, that
Yeah.
I had left before the passage of the oversight bill.
Right, it's brand new.
It's
Yeah.
brand new, and I'm hopeful that it will develop into something as robust as the Judicial Qualifications
right,
Commission, the
yeah.
JQC, which does enforce ethical and conduct guidelines against judges and has been very successful with it. And I'm hopeful that this age, and now a lot of DAs don't support it, but if you remember back when the JQC started, there were a lot of judges who didn't support
True.
it because no constitutional officer willingly submits to a limitation or of the authority they're granted by the Constitution. Nobody wants to do that. So yeah, I'm not arguing against guardrails.
I know, but you're helping flesh out what's an underlying tension, particularly in Fulton County. Can
Right.
Fulton County impose ethical guidelines on prosecutors?
It would be my opinion, based on the case law, that no, they
Right.
can't. When you talk
And
about
I also want to highlight, I want to highlight, Denny, real quick too, that I just want to reiterate that that's a single county. So for those of us, if you said the county can start implementing their particular restrictions on the district attorney, you got to think I'm over here with Fayette County, who has a very different set of needs than my Pike County or my Upson County people. And I want to reiterate and back right up on something, because I think this is important. When it's budget time, for those of us with multiple counties, I'm going to the Fayette County County Manager, the Spalding County County Manager, Pike County, and Upson County, and I'm meeting with all of them and then presenting to the commissioners that want me to present to them. So I'm getting checked at the state level. I'm getting checked at the county level. I'm getting checked, all over the place. So I just, and I know Wright's the same way. So I just want to kind of draw back the lens a little bit from just a single county. Sorry, Danny, I didn't mean to interrupt you.
I have been thinking about that as well. So one of the other issues that's come up is procurement guidelines. County personnel guidelines, we just discussed, is about as deep as we can get. We can't solve that problem today, but we can highlight that that is a problem. The other is county procurement guidelines. There was an audit done in Fulton County recently, which was highly critical of the district attorney's office. And part of the reason is that the district attorney's office essentially wrote them a letter saying, we've got prosecutorial discretion that allows us to hire any expert witnesses or special prosecutors that we want to. And you can't tell us what to do. And there's some worry in Fulton County that DA's office has extended that to buying other goods and services, that they don't have to have fair bidding procedures in place or whatever, that they can do what they want because they're not bound by those procurement processes, even though they're funding all of that peripheral spend, everything other than salaries. And I'd love any feedback y'all have on that, is what input should or can a county have on you in the procurement policies?
Well, as the former representative of a large county, I would say that I was pretty typical of people of my generation, is that we voluntarily submitted to follow P-card usage guidelines that were promulgated by the county, purchasing rules, and in fact, they have a purchasing department that you just say, I need a computer, and you call them up, and then they do all the bidding and searching for other items. Now, if you ask me under current law, could I have been forced to do that? My answer would be probably not.
Okay. Well, that's what Dexter Bond, who's kind of the number 2 guy in Bonnie Willis's office, said. He wrote to the auditors in Fulton County and said, the ability to contract these services are left to our own discretion, and no one has the authority to challenge this discretion. Basically, go take a flying leap, Fulton County, I'm going to do what I want with my procurement. And you think legally, she's right. You could do that, maybe not politically wise, but
Right. I mean, I think legally that under current law, that is a somewhat inartfully put but correct position. But I think he's right.
Okay. So my next one is on special prosecutors, and then I'm going to let Senator Jones ask some questions before we leave this topic. Does that suit you, Harold? On the special prosecutors, I believe this is under 15, 18, 20, right? You got the code there apparently in front of you too when hiring the district attorneys and deputy district attorneys and other attorneys, investigators, or whatever, is covered by that code section. And subsection B says, personnel employed by the district attorney pursuant to this code section shall serve at the pleasure of the district attorney. So now we're back to prosecutorial discretion. It makes a whole lot of sense if you're going to hire an expert witness or a prosecutor or whatever. And shall be compensated by the county or counties comprising the judicial circuit. The manner and the amount of compensation to be paid is to be fixed either by a local act or by the district attorney with the approval of the county or counties comprising the judicial circuit. That is being interpreted by Fulton County, that they had the power to approve the $700,000 that Mr. Wade has made, but they weren't allowed to. It's been interpreted by the DA in Fulton County that I'm paying whatever I want to pay them and hire who I want to pay. Do you guys have views on how that, what checks and balances does a county have in your use of a special prosecutor? Let's talk a little bit about funding for them. How is that ordinarily done? Danny, you've told me, I know PAC has a system in place to provide prosecutors. If you could walk me through how that works, and then I want views of all of you on, is there any check and balance on what a DA does as far as hiring special prosecutors and paying them? And we've got a special prosecutor here in Fulton County that's made 3 times what the DA makes. Wow, you know, and this just here, I'll start with you because you got the seniority.
I have to plead ignorance on the special prosecutor because I never used one in all the time.
In your 40 years, never ever used a special prosecutor.
My predecessors, I never saw one in the office, and I've never used one. So,
how about you other guys? Have y'all, other DAs, ever used a special prosecutor or know of that being done in counties near you?
So, in talking to some of my fellow DAs, it appears to me that at least in smaller offices, there are 2 ways in which you would see a special prosecutor come in. And one of them is, I say free loosely, it's already paid for by the taxpayer dollars. PAC has a branch within itself of a team of attorneys. Sheila Ross is a special, she's an attorney that goes around the state. She's handling the murder case in Athens of the UGA student, but her specialty is death penalty work. We did not call her in to help us officially with our 2 death penalty cases that we tried over the last 3 years, but we certainly used her as a resource. PAC has an elder abuse prosecutor. They have an animal cruelty prosecutor. They have a RICO specialist. Prosecutors, DAs can contact PAC and at no cost to them request PAC's assistance for additional attorneys within PAC's organization. That's one way.
Are those additional attorneys employed by PAC, or are they just at other district attorney's office and developed expertise?
No, they are within PAC and within PAC's budget, which is separate and apart from the DA.
So they've got another little pack of attorneys there that are like glorified assistant DAs with specialties?
You still have to swear them in.
a special prosecutor.
I've used it one time officially, and that was on a big RICO case out of Jones County. We brought in a PAC attorney, swore him in. His name was John Reagan. Another way that you will see DAs use special prosecutors is somebody, I don't know if y'all are familiar with the name, but Michael Lambros, and what he specializes, he's not with PAC, but what Lambros does and markets himself as is having a specialty with civil forfeiture proceedings. I've never used him, but he has gone around the state and developed a reputation of having an expertise in that. Some of those cases are very complex, and those district attorneys can either hire him per hour, and I think, again, I've never used him, a percentage of whatever the settlement is on the civil forfeiture. I've never hired somebody, a third party. I can only talk from my experience. If I did that, one, I'd have to have the money, which I don't, to do that. But if I did, it would be somebody that had a special skill set that I myself did not have or did not have within my office. It would be somebody that was very, very experienced at whatever the type case we were prosecuting.
And Mr. Chairman, if I could,
go right ahead.
if you're talking about special prosecutors as conflict counsel, which is you declare a conflict.
That's a whole different type than what we've talked about so far.
Right, independently hired. I want to correct my testimony. I've used conflict counsel.
Tell us what would create a conflict. Give us an example of how you.
For instance, we discovered in an initial investigation that a judge was involved in a criminal activity in the later years of my term. I immediately called GBI to do the investigation, and then prosecuting attorney's counsel, I declared a conflict, which basically
You
means
said you had a conflict.
I had a
'cause you were
conflict
buddies
because it was
with
a
that
judge.
or whatever.
Correct.
Okay.
And then they sent employees of prosecuting attorney's counsel, and I swore them in as special assistant DAs. And I've done that
That's done.
maybe
common.
5 times over the 27 years.
Okay, got it. That's a different type of special prosecutor. That's
Right.
a prosecutor provided by PAC if the local DA's office has a conflict.
Correct.
themselves.
But I've never hired
Yeah.
an expert prosecutor that is there to be like an assistant DA that has a skill set that,
Okay.
like John Floyd is a RICO specialist.
So back to the special prosecutors. PAC also has people that they can provide or recommend if you need special expertise or don't have enough manpower to
Correct.
do that in your office.
And they'll do it through you just request the special prosecutor, and that's something that has developed since I was the chairman, but we were in the process of developing expertise through hiring.
And when you say it's free, you're just saying it's not coming out of your budget. You don't have to go beg counties for money. That is state-funded
Correct.
through an appropriation to PAC.
That is correct.
Marie, have you ever used a special prosecutor? Okay.
Same, no, I won't belabor the point, Mr. Chairman. No, I've never used one other than through PAC. Right now, PAC is handling a case along with the Attorney General's office in conjunction with my office. But again, that's no cost any additional cost to my county. So no, I've never brought in somebody from the outside. It's always been from PAC. If I had a conflict, for example, a family member was the victim of theft, then another DA's office came in and helped out with that case. But those are the only circumstances where I've used anything like that.
And then sometimes in the conflict cases, Pete will ask another DA or
Right.
say me as a retired DA to go on the conflict case.
And on those type of cases, the local DA doesn't have to pay you. You're paid by PAC.
I'm paid by PAC.
All right, so,
The princely sum of $58 an hour.
all right. That's, you should work in Fulton County. Couldn't resist. All right, what time we got? Senator Jones, would you like to ask some questions now or take a break? All right, I'm going to turn the mic over to Senator Harold Jones, who has the privilege as a minority member to ask questions as well, and I'm going to let him flesh out. If we can limit it to the subject matters that we've covered so far, then we'll take us a lunch break and come back. And I really do want to talk about special grand juries before we let you guys go. And there may be other topics, and Senator Jones, you can confer with me too. We'll, while we have this brain power here before us,
Absolutely.
let's utilize them. All right?
Thank you.
Floor is yours.
I just only had a couple, Mr. Chair. One of them was other than total state funding, has there been any conversation about changing the formula that we use on funding you guys from a state perspective? Because if you're basing it on the number of judges, you get the ADA on number of judges, which is based on their workload assessment, which is to me, very flawed about how that process works, which then is going to impact the number of people that you have. Have you guys had any internal conversation about changing that kind of formula, how we would do that to get you more people?
I can't speak for everybody. There's 50 DAs and PAC. I would welcome that. I know that there's been sidebar conversations. There's been some conversations in DA meetings. I think that the structure, I'm only speaking for me, the structure that you speak of is outdated and certainly needs to be revisited.
During the time that I was the chairman of PAC and was working with PAC, there were several proposals that were floated by some of the committees or some of the leading members of the legislature, and there was not a lot of interest. So what we've traditionally done is work within the framework of the scheduling or the numbers, the formula, so to speak, and try and raise DA salaries or raise assistant DA salaries and obtain more people under the formula.
I want to add to that that right now, starting salary on the state scale for assistant district attorneys is at $58,000. And so I just heard one of my fellow DAs in the back of my head want to point that out, because if y'all were to give us more positions, we would gladly take them and be thankful for that. But I think we also have to understand, again, going back to Irwinton, Georgia, who wants to come to Irwinton, Georgia for $58,000 when they got $100,000 in student debt? So part of that in trying to figure out how to work this is going to be the competitive pay piece. And yes, I've got attorneys right now that are sitting there with 200 cases apiece. And it's just, when you have that kind of caseload, it's very difficult to provide the services that we want to provide, that y'all want us to provide, and the time. I walked in yesterday and watched one of my advocates spend over an hour on a misdemeanor case with a victim. And she's got hundreds of cases herself. So there's just a lot there to unpack.
Absolutely. Anyone else? My second question was, it seemed like District Attorney Porter, when you were talking about the +2, you mentioned about not actually wanting a position because the way it was going to be structured or kind of restricted, it seemed like. The juvenile position. Would you like to see any kind of loosening on those restrictions, whether it's a drug court prosecutor, juvenile prosecutor, or maybe not, or just give you a +2 and let you guys determine how you want to use that +2 from that standpoint? So you wouldn't have to say, I don't want the position because the restrictions are just going to stop me from doing what I want to do.
I think in certain circumstances, it would probably be better just to allocate a position, an assistant district attorney position, so that the district attorney, but you always have to guarantee that the drug court is staffed and that was the interest of the legislature. The drug court is staffed, the juvenile court is staffed as adequately as the state provides, and so I think it's hard not to, because with the juvenile court, for instance, some counties had to get a juvenile court started in order to qualify for the position. So they had to create a juvenile court because it wasn't in the county. Some circuits had to. So I'm not sure that loosening any restrictions would accomplish what DAs need to do on the ground. Okay.
And then my last one was, all of you had mentioned about the funds being cut for the victim services from the federal government. What was the rationale for that? Or did you even get a rationale?
As I understand it, and I want to first say, don't quote me specifically on this, but the money we were receiving from the federal government came from fines and fees from U.S. attorneys' offices prosecuting certain cases. and I believe it was tied primarily to white-collar cases. And because those fines and fees have shrunk, the money that's available has shrunk. That would, again, to get really into the weeds and get the best answer to you, would need to be a question directed at Pete Scandalakis.
Okay.
Because I believe the forfeitures were already included in that.
Well, we can't use forfeiture money for salaries.
But if the feds cycle it through the grant process.
Right.
That may negate that.
Correct.
But that also brings up, there is a fourth source for some DAs, and that's forfeiture money. And that, there are restrictions, there are reporting restrictions, there are spending restrictions that are codified in state law. And some DAs get a tremendous amount of forfeiture money and some don't, and it varies.
But that cannot go towards salaries.
You can't use it for salary.
But there again, there have been times where that forfeiture money, unfortunately, has not been spent correctly, in my humble opinion. It's got to be for training, supplies, vehicles, but now a vehicle doesn't mean a Range Rover. I mean, a vehicle means something practical. That's my opinion.
Yeah. That's all I have, Mr. Chair.
All right, thank you, Senator Jones. We're going to take a lunch break, and we have lunch provided down in the Senate mezz, which is down the stairs right at back entrance. There's, if you would please give preference to committee members, witnesses, and my favorite court reporter first, but others, press, and those in attendance are welcome to partake.